All right, class, I wanted to give you a little lecture on our midterm exam, kind of go through the answers real quick, and hopefully it will answer any questions that you may have had after seeing your results. So let's start with what is the initial pleading that begins a lawsuit? Well, that's called the complaint. Okay, that's where it begins. It all starts with a complaint. Um, Next, what is the second step of a lawsuit? Well, that's a summons. It's not an answer, it's a summons. So once you get your complaint, the next thing you got to do is you have to get a summons. You have to, the summons is the document that is served with the complaint that informs the party that's getting sued that there's a lawsuit against them. Depositions can be taken of whom? Pretty much anybody. The answer was all the above. The difference between depositions and interrogatories is depositions of anyone. Interrogatories are mainly just parties. So let's kind of talk about that because that was an actual question. Interrogatories are allowed to be taken of whom? The answer was plaintiff, because in most of your cases you have a plaintiff and a defendant. Now sometimes they're called different things, and they can be called respondents and petitioners and all kinds of stuff. But for the most part, plaintiff, defendant. Interrogatories are taken of parties only, so the answer was plaintiff. Next up, what is voir dire? Now, voir dire is a fancy Latin word that means selection of a jury, okay? Selection of a jury. Voir dire. Which of the following is not a form of alternative dispute resolution? So, alternative dispute resolution, in a sense, by very definition, is any form of conflict resolution that results in negating the need for trial, okay? So the answer was, which of these is not a form? Well, it would be trial, because that is the very definition, is avoiding that process. Which of the following is not a branch of the U.S. government formed by the U.S. Constitution? Well, the Constitution formed the executive, legislative, and judicial. So the answer would have been Parliament, which is not a branch. Which clause of the U.S. Constitution affords federal law to state law if they conflict? That is the Supremacy Clause. The U.S. Constitution says that federal law is the supreme law of the land, such as the Supremacy Clause. Next question, which clause in the U.S. Constitution gives Congress the power to regulate interstate commerce? Well, fortunately for us, it's the clause that's exactly like it sounds. It's the Commerce Clause. Okay, so the Commerce Clause is the answer to that. Goods that travel across state lines, those are interstate commerce. I always think of I-75 or I-95 being an interstate that goes all across the nation. So things that cross state lines, like interstates cross state lines, we call those interstate commerce. Now, goods that stay inside of states, those are intrastate, okay? So interstate, it leaves, intrastate stays inside. Next question was, what year did the Civil Rights Act passed? It was 1964. Civil Rights Act in 1964. Next question, in what year was the Americans with Disabilities Act passed? That was 1990, okay? Which seems crazy. We didn't have any federal protections for folks that were disabled until 1990, but we didn't. Under the Civil Rights Act, which is not a protected class of person. Okay, so what the Civil Rights Act aimed to do is it aimed to protect people upon their race, color, national origin, and religion, okay? And one of our selection choices in there was gender. So gender would not be the right answer. So that should have been the selection that you made. Which of the following forms of businesses are governed by the Civil Rights Act? The correct answer was all the above, okay? All the above. Civil Rights Act talked about gas stations, hotels, restaurants, and forms of entertainment. So those were on the list. So the correct answer was D, all the above. Which types of damages are available under a violation of the Civil Rights Act? The answer was C, both A and B. So A was injunctive relief and B was reasonable attorney's fee. So injunctive relief means that, say, a gas station won't sell gas to someone because they're from Italy. This makes the court forces them to start doing that. And reasonable attorney's fees provision gave someone who didn't have the money to have an attorney the ability to sue a business. And those are the two forms of damages available under a Violation Act. Are private clubs exempt from Civil Rights Act? Yes, they are. As long as they fulfill all the requirements, they absolutely are exempt. So, our next question is, does the tort of battery require intent? Absolutely. The answer is yes. So, it's an intentional tort. So, it requires intent. Additionally, does the tort of assault require intent? Absolutely. Because it is, once again, an intentional crime. You have to intend to put the person in immediate apprehension of harm. Okay? Does negligence require intent? No, it does not. Okay, negligence does not require an intent. Negligence, by definition, is when you fall below the standard of care. Not because you meant to, but because you were negligent. So negligence does not require an intent. And our final question is, which is not an element of negligence? Well, the answer is intent. So the elements of negligence are duty, breach, causation, and damages. Intent is not an element of negligence. Intent has nothing to do with negligence ever. And at the end of the day, that's what negligence is all about. It's all about just, you made a mistake. It was an accident. You didn't mean to do it, but you still probably owe the people some relief, some damages, whatever it is, because of the mistake that you made. That's kind of the difference. So that's just kind of our midterm review. I just wanted to go over the questions and just kind of briefly touch on each one of them. And thank you guys for your time, and we'll see you next time.